SJC-12799, Commonwealth v. Larry Watkins, and SJC-12969, Commonwealth v. Larry Watkins.
Good morning, everybody. We'll start with Mr. Tretyakov.
Turn this off.
Good morning, Your Honor. May it please the court. My name is Constantine.
I'm sorry, if everybody could mute, we're getting some background noise, please, until you're ready to speak. Please continue, counsel.
Thank you, Your Honor. Good morning, Your Honor. May it please the court. My name is Constantine Tretyakov from the Middlesex County District Attorney's Office. I represent the Commonwealth. In this case, the motion judge abused his discretion when he allowed the defendant's motion for a new trial. That decision fell outside the range of reasonable alternatives for three reasons. First, the defendant was stopped from arguing the sufficiency of the evidence after he obtained the determination of that issue on direct appellate review by this court in 1978, and he also raised this issue in his 2003 motion for a new trial, which was adjudicated upon by another superior court judge and by a single justice of this court. Second, the evidence presented at trial was legally sufficient to prove beyond a reasonable doubt that Theodore Watkins, the defendant's brother, knew about the robbery of the victim's car when he shot to death the victim curled up in the trunk of that very car. And third, the motion judge did not have authority to overrule this court and the single justice of this court on the legal issue of sufficiency of the evidence.
Well, let me ask you about your Rule 30 argument on waiver.
Yes,
the text of Rule 30 allows a judge in the interest of justice to revisit a conviction. And we've said that we'll consider, in Randolph, we said that we consider whether a claim is raised for a successive time on the standard of review, but we've never had strict waiver for a claim to be revived in the interest of justice. So how do you get around our case law, Brescia and some of the other cases on your waiver argument?
Thank you, Your Honor. In this respect, in this specific case, I would say that the fundamental jurisdictional requirement to grant a motion for a new trial is, under plain language of Rule 30, is when justice may not, it appears that justice may not have been done. In this case, this court decided the question of legal sufficiency of the evidence in 1978. That issue was again resolved by the single justice of this court in 2004.
But isn't that estoppel? So if the same issue was raised, and counsel will dispute this,
correct,
counsel, but that's more whether we decided an issue, and that's more of estoppel than it is waiver, correct?
Correct, Your Honor. I guess I would just say that in this specific case, where the question of sufficiency of the evidence, which is the question of law by definition, was decided by this court, when the law of joint venture, which is at the center of the defendant's motion for a new trial, has not changed since 1978. Indeed, when this court decided Commonwealth against Zanetti, it took pains to emphasize that the formulation reflects the common law and is hardly new, to quote the language from the court's opinion.
It seems like you're more focused on estoppel, so let me ask that question. Is it true that in the prior proceedings in front of single justice Cordy, the emphasis was more on participation and knowledge versus one was more on participation, the other one was more on knowledge? There were the different variants of one's liability as a joint venturer, that being the brother.
Yes, Your Honor.
Can we parse what was before the single justice in 2003? As counsel did, what's wrong with that analysis?
Yes, Your Honor, that analysis I would submit respectfully to the court would be wrong under Commonwealth against Gunter, that is 459 Massachusetts reports at 480, where the court said that different theory does not mean new. The case law does not seem to allow for the defendant to split hairs and infinitely find the different facets of the same legal issue. The question and the test is whether or not the issue was available to the defendant on direct appellate review, or at most in his first post-direct appeal motion, in this case, motion for a new trial, whether the law has changed so much that the issue becomes available to the defendant, and or whether the facts of the case change so much, for example, a new piece of evidence is introduced, that the issue becomes available to the defendant. None of that happened here.
I followed you on Gunther, which deals with splitting hairs and reviving an issue that was settled. That's more estoppel, but then you lapse into waiver language. So that's the problem I'm having, is estoppel and waiver are two different categories. You seem to be conflating them.
Your Honor, I would respectfully suggest that I probably should have been a little bit more clear in my brief with respect to that. What I was arguing, the primary argument is estoppel. The defendant obtained the determination of sufficiency of the evidence on direct appellate review. He argued it again in 2003, unsuccessfully. He is stopped from doing that. If the court determines, although, again, I would respectfully suggest that it will not be a correct determination, but if the court decides to proceed, nevertheless, on the analysis of the defendant's sufficiency claim, saying that he is not stopped from doing that, in that case, the court should rule that the defendant has waived it, because he did not raise it until 43 years of the defendant after his conviction. So regardless of the route to which the court chooses to arrive to the conclusion remains the same. The claim that it was an abuse of discretion.
All right, thank you. I think Justice Kafka has a question.
Doesn't Randolph really remind us we've always got to do a substantial risk of a miscarriage of justice review? We don't want to do these type of technical estoppel or waiver issues if the conviction is not consistent with that. So why don't you address whether there's any risk of a substantial miscarriage of justice here?
Yes, Your Honor, and that was the second argument that I introduced at the beginning of my oral argument today. So in this case, the evidence presented by the Commonwealth, and in the defendant's case as well, because no motion for required finding of not guilty was filed, so the defendant's rights were not fixed, and the court can view the evidence in the Commonwealth case and in the defendant's case to determine the sufficiency issue.
Well, I need to stop you right there, and you can continue to answer Justice Kafka's question. Wasn't there an oral motion for required finding?
I do not believe so, Your Honor. I have not found it in the trial transcript. The Commonwealth...
Well, we'll have to look at the transcript carefully. I'd be shocked if there wasn't, but please continue answering Justice Kafka's question.
Yes, Your Honor. Just to very briefly address your question, the Commonwealth rested, that was on page 952. All pages are consecutively paginated. And the defendant rested on, my apologies, Commonwealth rested on 878 and defendant rested on 952.
But why does it matter? If it was based on insufficient evidence, there's always going to be a substantial risk of a miscarriage. But
correct, Your Honor. But in this case,
forget whether or not they moved for required finding. Please continue to answer Justice Kafka's question.
Thank you, Your Honor. In this case, the evidence at trial established that both the defendant, and of course, when we are in the sufficiency of the evidence, we view all evidence is viewed in the light most favorable to the Commonwealth, and all inferences are drawn in favor of the Commonwealth. In this case, the defendant and his female companion, Theresa Nelson, arrived to Boston by bus. The reasonable inference from that is that they did not have a car. Theodore Watkins entered the car after the defendant was in the trunk of the car, or as the defendant told Detective Nally, that he and Theodore Watkins together forced the defendant into the trunk. That doesn't really matter. They drove with the victim in the trunk of the car, with Theodore Watkins in the car, for about an hour, during which there was a conversation. And the defendant also told Detective Nally that the plan was to merely tie the victim up or abandon him in the alley. The defendant then provided Theodore Watkins with a gun. After that, both of them exited the car, opened the trunk, pointed the gun to the victim's head. Theodore Watkins did that, shot the victim. The victim was alive for approximately half an hour after the homicide occurred. After that, Theodore Watkins and Larry Watkins, the defendant in this case, took the body out of the car, placed it in the woods nearby, covered it with leaves, and then Theodore Watkins drove the car back to Boston. That provides the jury with, I would submit, more than ample evidence to conclude that Theodore, again, viewed in the light most favorable to the Commonwealth, or frankly in any light, Your Honor, that Theodore Watkins was acutely aware about the armed robbery of the victim's car. And the judge specifically instructed the jury that they could find armed robbery based on the robbery of the automobile.
Justice Swink has a question.
I do. I want to know whether this is based on the testimony of the detective alone, your version of events now.
Your Honor, this is partially based on the testimony of the Detective Nally, who interviewed the defendant back in Kentucky, and also based on the testimony of Theresa Nelson, who was in the car with the defendant and Theodore Watkins when these events occurred.
Well, I don't think so. I think that her testimony seems to be quite different than his, than what you're saying now. I think it's maybe supportive of the theory that was there before, but not the theory that you're arguing now.
Your Honor, I think the stories that the defendant and Theresa Nelson, that the defendant told Detective Nally and Theresa Nelson told the jury, they were not exactly the same, I would submit, but again, for the sufficiency of the evidence purposes, all conflicts in the evidence, if there are any, are resolved in favor of the Commonwealth, and all evidence is viewed in the light most favorable to the Commonwealth.
Back during the trial, the Commonwealth seemed to embrace the cooperated witnesses version of events, right? And then what you're saying is, well, even if that happened, there was still other evidence, that being the confession of the defendant or the statement of the defendant, which supports your theory now, correct?
Your Honor, the argument that the Commonwealth presented to the jury in the closing argument was based, I would submit, both on what the defendant told Detective Nally and what Theresa Nelson told the jury. And the defendant spent some time in his brief arguing how supposedly unfair it is for us to introduce a new theory. We're not introducing a new theory, Your Honor. A theory has always been joint venture felony murder. That was one of the theories of the murder in the first degree that the jury found the defendant guilty of. As to the issue, for example, of when precisely the defendant was put into the trunk of the car, that has nothing to do with the elements of that offense. Your Honor, I would be more than happy to address any other questions that the court might have. I'm just mindful that there is the appeal of the defendant from the single justice's order. So I just wanted to make sure that I have time to address that.
Why don't you do that? Because, did you have a question, Justice Budd? I'm sorry.
Along those lines. So I was just procedurally, I was trying to figure out what the new, I understand it's substantial, but what's the new issue here that we're supposed to be looking at? Why isn't it just that, you know, the motion judge made his decision, and because there's no new or substantial issue, or no new issue, because as you said, this thing has been decided already, whether the motion judge was right or wrong, how is it that we get to look at this?
Yes, Your Honor. I believe in Commonwealth against Smith, which the single justice cited to when he allowed the Commonwealth to proceed with appeal to this court, it was emphasized that this criteria of substantial and new is somewhat relaxed with respect to the Commonwealth's claims. And I agree that if interpreted quite literally, this is not a new issue because it is literally 43 or 44 years old by now. But at the same time, it is definitely a significant issue which is worthy of consideration for this court because, as the Commonwealth argues, there plainly was an abuse of discretion by the motion judge.
Don't we have to go backwards? Whether the motion judge is only supposed to deal with this if there's, right, a nuance. When the motion judge sort of conflates whether there's a new issue, right, and there isn't a new issue, and then he grants the motion improperly, that changes the standard review. We've got different standards in that context of whether the single justice should intervene or not, right? There are a bunch of cases on that. So yes. If the motion judge creates a new, if the motion judge confuses, there's no new issue raised, grants a new trial, then the single justice has this on review. It changes the standard of review for the single justice, right? Because you basically have a substantial issue that a murder conviction is being reversed when they're for the wrong reasons, right? So,
Correct.
Yeah.
Correct, Your Honor. If I may just briefly, I know that my time is almost up, Your Honor, but if I just may very briefly address the defendant's appeal from the single justice's order.
Go ahead.
Thank you, Your Honor. In this case, the standard of review for the single justice's decision is abuse of discretion, and the single justice did not abuse her discretion when she vacated the order allowing the defendant's motion to stay the sentence.
Well, let me just ask you briefly, the trial judge, at least under, as you say, under Rule 30, had some discretion to grant a stay. The single justice respectfully didn't make any findings, so how do we know there was an abuse of discretion when there are no findings?
Your Honor, I would say that under Commonwealth against Watkins, this court has emphasized that sort of following the logic of Commonwealth against Watkins, if the single justice reverses or vacates the decision of the trial of the motion judge in this case to stay the execution of the sentence, that is clear exercise of independent discretion by a single justice, and then this court reviews that decision for abuse of discretion. The defendant was not entitled to the stay of execution of the sentence, if anything, because he is not serving the sentence technically right now. He is definitely in custody, but his motion for a new trial was allowed, so he is not serving the sentence, so it's impossible to stay something that does not exist, which is why Rule 30C8A provides those defendants who found themselves in that situation with a specific procedural remedy, which is to ask the defendant, to ask the judge for bail, which, as Your Honor just said, is vested with the sound discretion of the judge. In this case, this is what the defendant did in 2019. He obtained that review. His motion for release on personal recognizance bail was denied. And then he did not appeal from that ruling. He did not file a motion to reconsider. Instead, he filed a motion to stay the execution of sentence, which again was not procedurally available to him in this case. And following the, again, Commonwealth against Watkins, which is the most recent case that I could find on the factors pertinent to bail of the defendant in a first-degree murder case, it is plain that the single justice did not abuse her discretion because the nature of the murder was egregious. The Commonwealth case against the defendant was strong. The community ties and the family ties of the defendant are virtually non-existent. He has no financial resources. Given the penalty attached to murder in the first degree, he presents a very high risk of flight. And of course, the health concerns of the defendant are not lost upon us as well. But if the court takes judicial notice of the Special Master's Weekly Report in Commonwealth,
I don't think you want to go there, given what happened in the last week. But I'm going to cut you off. Your time is up, and I'll turn to. That's quite all right. We'll turn to Mr. Fallon for the defendant's first argument.
Good morning, Your Honors. Richard J. Fallon for Defendant Appellee Larry Watkins. I'm only going to deal with the single justice, the gatekeeper allowance of the Commonwealth petition for appellate review, which brings me to the Commonwealth completely confused Rule 33, I'm sorry, Section 33E and direct estoppel when it talks about Gunter and New, because the Commonwealth is the petitioner here. Gunter deals with Section 33E. And, you know, if you want to, under 33E, if there's no new issue, what happens? The appeal does not lie. So if you want to dismiss the appeal, please go right ahead under Section 33E. Direct estoppel is quite different. Rule 30, the trial judge, the motion judge, had no obligation of a new. New does not appear in Rule 30.
So so what's before us, Mr. Fallon, is whether or not the judge erred in granting a new trial.
Right.
Okay.
And do you want me to go to?
Let's get to brass tacks on that one, okay? Great. And we'll talk about sufficiency.
Let's talk about sufficiency, Your Honor.
All right. Let me ask my question. Let me ask my question before you answer it.
Thank you.
Right? We have a felony murder by armed robbery alleged. There's a joint venture which, whether it's Zanetti or pre-Zanetti, requires knowledge about the crime, shared intent, and participation in some meaningful way. Here, the killing has to occur during the commission of the armed robbery, correct?
Yes, Your Honor.
Which can include attempts to evade responsibility, correct?
Yes, Your Honor.
So the issue is whether or not the brother was participating in this armed robbery when he shot the victim. Why isn't it the case where there's a victim in the trunk? It's not the defendant's vehicle. It's not the brother's vehicle. They clearly threw him in the trunk by force. I'm sure he didn't get in there on his own, you could infer. And he shoots him, as Justice Cordy recognized in 2003, to perfect some type of getaway. How is that not a joint venture?
I agree. That's the perfect thing. That's what they call. Sure, of course it's a joint venture for kidnapping.
No, it's an armed robbery of the vehicle.
How in the world, and this is great because you focused, but how in the world does Theodore, the brother, know there was a robbery of the vehicle? And everything.
You think he was just going in the trunk for fun?
No. There's a kidnapping. Again, I agree. I'm not contesting that Theodore. Are you saying that every kidnapping comes from a stolen vehicle?
Well, there has to be a deprivation of property, correct? By force. How'd they get the car? They take the car.
How does Theodore knew they stole the car? That's the whole question that everybody's missing. Even I missed. Let's assume hypothetically that Theodore watches my client bring by gunpoint the poor victim, Mr. Keene, into the trunk. How does he know it's a stolen car? I can give you 4 sites. Please let me give you the sites of kidnappings where there were not stolen cars. In fact, one of the cases cited.
That's because those are just the charges. Can you have any cases that say when someone shows up in a car and the victim's in the trunk, they didn't take the car by force?
Well, I don't have the trunk. Well, I have a couple of cases. Your Honor, there's 1,000. I can tell you why would be in the trunk. I can give 100 different reasons. Start off. Maybe
like
this
a college
fellow.
prank?
No. Maybe this other fellow was beating up their sister and he got mad and put him in the trunk. Maybe it was an extortion. There's a number. That's the key point. You've hit.
Are you saying in the light most favorable to the Commonwealth, there's not enough evidence to say that the defendant, the shooter, Theodore, knew that the car was stolen?
Exactly, Your Honor. There's no evidence. For example, look at all the facts that the Commonwealth mentioned. They arrived by bus. Mr. Nelson and my client arrived by. How does Theodore? There's no evidence that Theodore knew that. There's a conversation to tie him up. That has nothing to do with an armed robbery.
So your brother shows up with a new car and you say, hey, nice ride. Oh, by the way, there's someone in the trunk who owns it?
Why did he get, the real question is, why did Mr., under the evidence, favorable to Commonwealth, why did my client steal the car? There's no evidence that Theodore knew why. No, even knew the car was stolen. Why is the kid, I'm sorry, I got it wrong. Why was there a kidnapping? There's no evidence that Theodore, he could have been, hey, he could have told them a million different things why there's a kidnapping. Why do people kidnap people? I can give you the last case I argued before you was in 2018 Parker, one of those horrible Harvard Pitt killings. There was a kidnapping there, but it was murder. There was no theft. And in fact, the car was owned by one of the participants. There's several other, in the case they cite Medeiros, where there's a kidnapping and robbery in the car. Indeed, it was a robbery, but the car was owned specifically by Bernier, one of the joint ventures.
I mean, I agree with you. I think that the wallet's out, correct? Because there's no evidence.
I don't care about the wallet, the car. I'm talking about the car.
I'm trying to give you a life raft. The wallet's out, right?
Yeah,
We just have to
well,
focus on the
They
robbery
don't
of the
care,
car.
but I'm focusing on the car, Your Honor.
Okay, me
McCoy,
too.
his employee, McCoy, there's a kidnap. I'll give you the site, Commonwealth McCoy, 456 Mass 838. It was his kidnapping. It was his employer's truck. Give you another site, Commonwealth versus Dos Anjos, 52 Mass Appellate Court, 531. His own car. He's trying to say anytime somebody's kidnapped, it's a stolen car. And that's simply not true. That's what you've hit the crux. That's the point. If can you infer from a kidnapping a stolen car?
So
The answer is no.
The lens is the light most favorable to the Commonwealth. Every reasonable inference drawn their way.
Yeah, but if it's only one, it has to be. It has every essential element. It's an essential element that has to be found beyond a reasonable doubt.
I agree with you on that one.
I mean, when all these cases you're bringing up, they have a right to the car. It's their car. It's their brother's car. This is a car out of nowhere, right?
How does the brother know it's a car out of nowhere? I don't get it.
Because the owner's in the trunk, maybe.
How does the brother? See, that's it. That's the whole point. How does the brother know that the owner of the car is in the trunk? I want to hear your answers. I really do.
I think you have to answer our questions, but let's proceed.
No, I know. And my answer is there's no reason to know that that fellow was the owner. We know he was kidnapped. And in fact, the real question is, go ahead. Yeah.
For the sake of argument, if there's no evidence, even in the light most favorable to the Commonwealth, that Theodore knew the car was stolen,
right?
Would it be a new trial or a second degree?
Oh, no, definitely a new trial. Because it's match it. It's the classic insupportable ground, Your Honor. Match it and Floyd P. It'd be a new trial. Because I'm going
to try and finish my question too.
I'm sorry. I apologize.
That's okay. Why wouldn't it be a second degree felony murder if you were right?
Because, and again, that's the whole kidnapping armed robbery. The Commonwealth could have easily charged felony murder, kidnapping, but they charged felony murder, armed robbery. They're not lesser included, because the classic lesser included is all the same elements plus one or minus one, and kidnapping and armed robbery don't have the same elements. And that's my last argument actually in my brief, because they're not lesser included. That's why it's a new trial, not second degree. See, this case is kind of simple. And I think we can infer that the Commonwealth, they could have easily charged felony murder kidnapping, but at the time, felony murder kidnapping was second degree, not first degree. Now it's changed, but then it was second degree. So really the Commonwealth's hoisting its own petard here, in the classic phrase. They charged the wrong underlying felony because there's no evidence. You can keep asking, evidence of the, so he said he was going to tie him up. So he's kidnapped. How do we know that the car was stolen? You say a new car, even if it's a new car. How does the brother know?
Was Justice Cordy wrong in 2003?
No, that's what he did. No, not at all. I'm not contesting. Well, I'm not contesting that. I'm not at all contesting, because for direct estoppel.
Why wasn't he wrong in 2003?
I don't need to argue that he was wrong, because that was about the duration of the robbery.
I'm asking you a question. Was Cordy wrong in 2003?
I'm not contesting him at all, Your Honor. I'm not contesting that at all.
So the answer is yes.
Yeah, the answer is I'm not contesting because I'm defending a client who may be under a new trial. So I don't want to concede anything for my defendant. I'll let the next attorney decide that. But I'm sure as heck not contest. My argument does not rely on Justice Cordy being wrong, because they're two different issues. One, and you know this, one, the issue before Justice Cordy for direct estoppel was about the duration of the robbery. I'm not saying the robbery had to be over, and indeed, we know that escape can be part of it, etc. So I'm not at all arguing that. I am arguing something that was never brought before anybody else. Nobody ever thought about this, and I can understand why, because I've missed a lot in this case. And see, nobody ever thought about whether the brother knew that the car was stolen. I mean, do you folks know your Your brother's car? What it
Well, if
looks
my
like?
brother, if my brother showed up
I
and
do know
someone
my
was
brother's car.
pounding on
Maybe.
the trunk and handed me a gun, I'd probably be a little suspect.
Well, you would, and maybe they talked all about it. Maybe there was a conversation all about it, but the Commonwealth didn't bring it out. I mean, the Commonwealth could have asked, what did you talk about? The Commonwealth never got that out. Sure, you'd be suspect. I loved when the Commonwealth wrote in its brief, well, there's kidnapping. They said, well, it implies foul play. Of course it implies foul play, but it doesn't imply armed robbery. That's the problem. There's insufficient evidence that the brother, there's really no evidence that the brother knew there was an armed robbery. There's no evidence.
I'm confused by that though. So
Okay.
the brother obviously knows there's a gun, right? Because the defendant
Exactly. Of course.
gave him the gun.
Yeah, the brother
The
shot.
brother, right. So the brother knows there's a gun. The brother knows that there's somebody in the trunk. It's not a reasonable inference. The brother came from Kentucky. He has no car, and he's driving around with someone in a trunk. You can't make a reasonable inference that he knew that they used the gun to rob the car. I mean, to take the car. I don't know. It just seems like most favorable to the Commonwealth. They seem to be reasonable inferences.
No, Your Honor, and I would say the mistake you made, with all due respect, is when you said he has no car. How do we know the brother knows he had no car? How do we know that they haven't talked in 5 years? We don't. We don't know. So that was again, with due respect, that was the error you made when you said he has no car. Brother doesn't know that he has. Brother does sure know that there's a kidnapping. Brother sure knows there's a gun. What was the kidnapping for? Kidnappings can be for a lot of different reasons. They can be for rape. They can be for, in fact, a couple of those cases I cited, it was for rape. They can be for a lot of reasons. It could be for extortion. They could be, like I said, we don't know if my client told the fellow, or according to the evidence, my client could have told him could have told him he beat up his sister. Why do you shoot a guy? It doesn't make any sense. For usually stolen cars, you don't kidnap the owner. I mean, that's a very weird thing anyhow. Why would you, if you're stealing a car, why would you kidnap the owner? That doesn't make any sense. That's probably maybe the best argument why there's insufficient evidence. That doesn't make it, this case doesn't make any sense. Why did the brother shoot him? We don't know. But that's it right there. What's the evidence? You notice the Commonwealth never explained, as they gave the recitation of the evidence, why this showed that the brother knew or was aware of an armed robbery of the stolen car, because none of it shows it. I mean, let's tie him up. They took a bus from Kentucky. Do we know whether the brother knew we took a bus from Kentucky? No, there's no evidence. So, I mean, that's it. I'm glad you there's a lot of other things, but I agree. There's the crux. I'm glad we got to it, because that's what it comes down to.
All right. Thank you, Mr. Fallon.
Thank you.
We'll turn to Mr. Nam Crane on the stay. If we look at it under Rule 30, subsection 8, C8, I think it is, did the judge still have the discretion to grant the stay?
If you look at it, I'm sorry, I'm under the bail provision of Rule 30, Your Honor. Are you referring to?
Yes. Yeah.
Well, I think then you'll be asking whether Justice Liu had the discretion to revisit bail, and I think that I have two answers to that. Number one, I think yes, because there's been changed circumstances, but also I think that again, and those circumstances would be COVID, I think, and whether the bail should be thought of again, in that light. But I think that I disagree with my brother in the Commonwealth about whether or not a stay of execution is not available in this situation, because I think it would be, I think both just on a commonsensical point of view, why is a stay of execution not available to a defendant who actually succeeded in his motion for new trial? But also in this court, in drafting Standing Order 520, which is not cited by the Commonwealth at all, and in the Christie case, this court recognized the urgency of trying to get people out of prison, out of facilities where they're susceptible to infection,
I don't disagree with you, and maybe that's something we should look at as well. But day of execution means that you don't go to prison. He was in prison, and there's Rule 30C8 deals specifically with someone who has a new trial that's been granted and allows a judge to set that person to bail. It seems to me that Judge Blue had the discretion in considering all the COVID factors and the changed circumstances to set him to bail.
No, I think I agree. However you look at it, I think Justice Liu, and these extraordinary circumstances, had every right, and I would say a duty, to try to find a way to get this older man with cancer and hypertension out of prison after he's allowed his motion for new trial. And I think that, and
then what do we make of the single justice order?
That's an excellent question.
I'm sorry, we're speaking over. Was that an abuse of her discretion?
Yes, I think it was completely capricious for her to not say anything at all. And Justice Liu's decision was very detailed, very well reasoned. I think the case law is instructive. First, I would refer to Justice Lowy in your decision in Vasquez, where you say that the decision must be accompanied by a statement of findings and reasons. And I think that, again, when we have this hierarchy of courts, for a judge to leave no reason at all, I think is just the height of hubris and capriciousness, where the judge knows that it's going to be reviewed. And below her is this very well-reasoned case. So what is the reliable decision here? I would submit Justice Liu's decision is the most reliable. Let
me ask you this. Are we looking at whether or not the single justice abused her discretion in determining whether or not there was an abuse of discretion?
Well, we don't know if that was her reasoning, because if it was her reasoning, I would say yes, it still was an abuse of discretion, because...
Well, you're saying, I'm sorry. So there's two things you're arguing. One, you're arguing that the single justice, the standard is, first, did she abuse her discretion in determining whether Judge Liu abused his discretion? And two, you're saying under Vasquez, you don't have to get to abuse of discretion because there's an error of law because there's no findings relative to Vasquez. Is that your argument?
Well, I mean, I think you've just added a third argument. One is the Vasquez, certainly, that, I think she should have had some sort of reasoning, some findings there, if we're going to look at this under Vasquez as a bail reasoning. But then keep it within the state of execution, either she abused her discretion in reviewing his discretion, or if she looked at it independently, which I think the case law would say that she might have the right to do that, that is also an abuse of discretion, because again, this is a person where he has no cognizable risk. He's 68 years old. He's a model prisoner. He hasn't been in trouble in years. And in light of the COVID and in this court's own stated desire to try to get people out of harm's way, this man, under CDC guidelines and in the Department of Corrections' old report of deaths, he is the very target population that is at risk for this disease.
Mr. Neal-Crane, the Christie, of course, dealt with stays, and we're not in a stay situation because he was in jail. We're in a release from a branch of a trial, which is different. But you asked us to apply the Christie overlay during the COVID pandemic to this situation.
Yes, Your Honor, because you obviously stated in the standing order and in Christie, and again, that's the changed circumstance. This is the extraordinary circumstance in this case, and it cannot and should not be ignored. So yes, I would ask you to look at it that way. Yes, and you were asking whether Justice Liu had the discretion to do what he did. I think he, not only had the discretion, I think there was every impetus to do that. And by the instructions of this very court, that he should be looking to do that if it's appropriate.
I think your time is up. If any further questions? Thank you, counsel.